This week's lecture has two main sections. The first looks at the remedies available for breach of covenant, with a special emphasis on the remedies of forfeiture and distress available to the landlord. The second main section looks at the ways in which a lease comes to an end. Of course, a fixed-term lease comes to an end when the term expires. As we will see, however, there are other ways in which a lease might end. Section 41.4 of the Conveyancing and Property Ordinance applies equally to breach of covenant by a landlord or a tenant, or indeed breach of any covenant concerning land. The general remedies that it specifies are injunction, ordering performance of the covenant, an action for money due, for non-payment of rent, or damages. Either party can also apply for a declaration. The court tells the parties what their mutual rights and duties are in some specific respect. Since the lease is a contract, either party can bring the lease to an end if the other commits a repudiatory breach and the other innocent party elects to rescind. I'll talk about forfeiture in a moment. This is the landlord's right, given by the terms of the lease, to terminate the lease because of some default by the tenant. Distress is a remedy available to a landlord when the tenant is in arrears with the rent. The landlord applies for a court order. This order allows a bailiff to go to the leasehold property, take goods in the apparent possession of the tenant, and sell them. The proceeds of sale are used to pay off the rent arrears. A lease will often contain a forfeiture clause that enhances the landlord's ability to bring the lease to an end in the event of a breach by the tenant. A forfeiture clause states that in certain events the landlord has the right to bring the lease to an end. These events will invariably include non-payment of rent and breach of any other covenant. The Landlord and Tenant Consolidation Ordinance implies forfeiture clauses covering non-payment of rent and breach of certain other covenants into leases of domestic tenancies. Whatever the type of breach, the forfeiture process usually requires the landlord to write to the tenant asking him to pay the rent or remedy the breach. There's no need to do this, however, where the breach is irremediable, where the breach of covenant cannot be undone by performing the covenant and the payment of damages. Breaches of covenant not to use property for immoral purposes have long been declared to be irremediable. The same is true of breaches of a covenant not to assign or sublet property. Where the breach of covenant is irremediable, the landlord has to serve notice on the tenant of the breach, but does not need to require the tenant to remedy the breach, nor to give the tenant reasonable time to remedy the breach. Even though a breach is irremediable, however, the court can still grant the tenant relief from forfeiture, that is, allow the tenant to keep the lease. If the tenant fails to pay the rent or remedy the breach after receiving the necessary notice, the landlord can either simply take back possession, provided this can be done peaceably, or seek a court order requiring the tenant to give back possession. The latter is safer because a landlord who simply re-enters can incur criminal liability if he isn't careful. A landlord loses the right to forfeit the lease if he waives the breach of covenant. A landlord could expressly waive the breach, or the waiver could be implied. This happens where the landlord knows of the facts that would entitle him to forfeit the lease, but then does something that acknowledges the continued existence of the lease. So, for example, there is a waiver when the landlord knows the relevant facts giving rise to a breach and accepts rent from the tenant. A waiver is retrospective only. The landlord can still forfeit if there is a further breach of covenant after the waiver. Finally, there is the idea of relief from forfeiture. If the landlord applies to the court to forfeit the lease, the court can agree that the landlord has the legal right to forfeit, but nevertheless grant the tenant relief from forfeiture. The tenant is then allowed to keep possession under the lease, provided the breach is remedied. Subtenants can also apply for relief from forfeiture. A fixed-term lease comes to an end as a result of the effluxion of time. That is because the lease term simply comes to an end. Second, a periodic tenancy, like a tenancy from week to week or month to month, is brought to an end by giving notice to quit. Third, if the landlord and tenant agree to bring a fixed-term lease to a premature end, this is done by means of a surrender. A surrender should be done by deed, but as we will see in the lecture, it's also possible for an informal surrender to take effect by operation of law. Surrender by operation of law relies on common law estoppel by representation. So, for example, there's a surrender by operation of law if the tenant gives back possession and the landlord accepts it, perhaps by emptying the property and giving back the keys, where it's clear that the parties intend a surrender of the lease. Fourth, merger. A merger occurs where the same person, acting in the same capacity, owns both the lease and the reversion. Perhaps the landlord acquires the lease or the tenant acquires the reversion. Fifth, forfeiture. We've already discussed forfeiture, bringing the lease to a premature end because of the tenant's default. Sixth, frustration. We know from a previous lecture that the contractual doctrine of frustration applies to leases. Seventh, and finally, disclaimer, trustees in bankruptcy and liquidators have the right, with the court's leave, to disclaim onerous property, and this includes leases. There are safeguards for third parties whose interests might be affected by the disclaimer.